credible allegation that someone had willfully violated Section 702 in a way that was in violation of a criminal law, we would investigate that case, and if prosecution were justified, we would prosecute it. I know Director McCabe shares with me that commitment. We recognize that we have an obligation to the American people to make sure that these authorities are used appropriately and responsibly, that we comply with the Constitution and the laws and the procedures, and we're committed to devote whatever resources are required to make sure that if there are willful violations, people are held accountable for them.
And this is your commitment and the Department of Justice's commitment to the American people.
That's correct.
Thank you, Mr. Rosenstein. Thank you, Mr.
Senator Feinstein.
Thanks. Thank you, Mr. Chairman. Just a couple of comments on Section 702. It's a program that I support. It's a program that I believe has worked well. It's a big program. It's an important one. It is a content collection program involving both internet and phone communications. So it can raise concerns about privacy and civil liberties. In the year 2016, there were 106,469 authorized targets out of 3 billion internet users. That's the ratio. The question of unmasking has been raised. It's my understanding that 1,939 U.S. person identities were unmasked in 2016 based on collection that occurred under Section 702. So my question is going to be the following, and I'll ask it all together, and hopefully you'll answer it. I would like a description of the certification process and the use of an amicus. I would like your response to the fact that the question, the program sunsets after 5 years, about raising that sunset versus no sunset because of the privacy concerns. It's my belief there should be a sunset, and the use of an amicus, which is currently used as part of the certification process, and whether that should be continued and formalized. So, Admiral, it's programs under your auspices.
I could, if I could. DOJ is going to be smarter on the amicus piece. Please, will you take that piece and all?
I'm not sure I am smarter on the amicus piece, Senator. I can tell you this, though, that with regard to the question of unmasking, this is actually primarily a question not for the Department. The determination is made by the intelligence agencies. If there is a situation where a foreign person has been communicating about an American person and a decision is made whether or not the identity of the American person is necessary in order for that intelligence to be properly used. I think what's important for people to recognize, Senator, is that's an internal issue. That is, that unmasking is done internally, within the cloak of confidentiality within the intelligence community. That's a different issue from leaks. In other words, if somebody's identity is disclosed internally because it's relevant for intelligence purposes, because that's the goal of this collection, is to understand.
Mr. Rosenstein, let me just tell you, I just listened to somebody who should have known better talking about unmasking in a political sense, that it's done politically. And that, of course, is not the case. And so what I'm looking for is the definition of how this is done and under what circumstances.
Right. And I think, Senator, that because that's really a decision made by the IC, the intelligence community, not by the Department, it would be appropriate for them to respond to that.
I can do that. So with respect to unmasking, the following criteria is applied. First, for the National Security Agency, we define in writing who has the authority to unmask a U.S. person identity. That is 20 individuals in 12 different positions. I am one of the 20 in one of those 12 positions, the director. Secondly, we outline in writing what are the criteria that will be applied to a request to unmask. In a report, and again, part of our process under 702 to protect the identity of U.S. persons as part of our minimization procedures, when we think we need to reference a U.S. person in a report, we will not use a name. We will not use an identity. We say U.S. person 1, U.S. person 2, U.S. person 3. That report is then promulgated. Some of the recipients of that report will sometimes come back to us and say, I'm trying to understand what I am reading. Could you help me understand Who is person one or who is person two, etc. We apply 2 criteria in response to their request. Number 1, you must make the request in writing. Number 2, the request must be made on the basis of your official duties, not the fact that you just find this report really interesting and you're just curious. It has to tangibly tie to your job. And then finally, I said too, but there's a 3rd criterion, and that is the basis of the request must be that you need this identity to understand the intelligence you're reading. We apply those 3 criteria. We do it in writing, and one of those 20 individuals then agrees or disagrees. And if we unmask, we go back to that entity who requested it, not every individual who received the report, but that one entity who asked for us. We then provide them the U.S. identity, and we also remind them the classification of this report and the sensitivity of that identity remains in place. By revealing this U.S. person to you, we are doing it to help you understand the intelligence, not so that you can use that knowledge indiscriminately. It must remain appropriately protected.
Thank you.
And Senator, if I could just add something to that, given the nature of this issue, and it's a legitimate question that you've asked, I've talked with my colleagues at NSA and CIA, FBI, and so forth, and suggesting that we might ask our civil liberties and privacy protection agencies to take a look at this, to see if Admiral Rogers laid out the procedures. Are these the right procedures? Should we be doing something different? Would they have recommendations that better protected people from misuse of this? And they've all agreed to do that. So I think it's a legitimate issue to follow up on. I've talked to the agency heads about doing so, and they're willing to do it.
And if I could, I also have an internal review that I have directed. Given all the attention, given the focus, let's step back, let's reassess it, and let's ask ourselves, is there anything that would suggest we need to do something different in the process?
Good. Thank you.
Mr. Chairman, with your permission, I'd like to more thoroughly answer the first question the Senator asked, which is, Senator Feinstein, my understanding is that an amicus was used in 2015. That decision was made by the court. It's the Foreign Intelligence Surveillance Court, which has the statutory authority, if the court believes it's appropriate in a particular case, to appoint an amicus. So my understanding is that was done in 2015. Thank you.
Well, would you feel it would be helpful to make it a part of the regular certification process?
Well, my understanding, Senator, is that the statute permits the court to do it if the court believes it's appropriate. So I believe the court has that authority, and I'd leave it to the judges to decide when it's appropriate to exercise that.
Thank you. Thanks, Mr.
Senator Rubio.
Thank you all for being here. I understand fully the need of the President of the United States to be able to have conversations with members of the intelligence community that are protected, particularly in a classified setting. I also understand that the ability of this community to function depends both on its credibility, that its work that it's doing is in the national security interest of the United States, and also the importance of its independence, that it is not an extension of politics no matter which administration is at play. And the absence of either one of those two things impacts everything we do, including this debate we're having here today. And the challenge that we have now is that while the folks here with us this morning are constrained in what they can say, there are people that apparently work for you that are not, and are constantly speaking to the media about things and saying things. And it puts the Congress in a very difficult position because the issue of oversight on both your independence and on your credibility falls on us. And I actually think if what is being said to the media is untrue, then it is unfair to the President of the United States. And if it is, then it is true, that it is something the American people deserve to know, and we as an oversight committee need to know in order to conduct our job. And so my questions are geared to Director Coates and Admiral Rogers. You have testified that you have never felt pressured or threatened by the President or by anyone to influence any ongoing investigation by the FBI. Are you prepared to say that you have never felt that you've never been asked by the President or the White House to influence an ongoing investigation?
Well, Senator, I just hate to keep repeating this, but I'm going to do it. I am willing to come before the committee and tell you what I know and what I don't know. What I'm not willing to do is to share what I think is confidential information that ought to be protected in an open hearing. And so I'm not prepared to answer your question today.
Director Coates, I would just say, and with incredible respect that I have for you, I am not asking for classified information. I am asking whether or not you have ever been asked by anyone to influence an ongoing investigation.
I understand, but I'm just not going to go down that road in a public forum. And I also was asked the question if the special prosecutor called upon me to meet with him to ask his questions. I said I would be willing to do that.
I likewise stand by my previous comment.
Okay, well then, in the interest of time, let me ask both of you, has anyone ever asked you, now or in the past, this administration or any administration, to issue a statement that you knew to be false?
For me, I stand by my previous statement. I've never been directed to do anything in the course of my 3+ years as the director of the National Security Agency
asked.
that I felt to be inappropriate, nor have I felt pressure to do so.
Have you ever been asked to say something that isn't true?
I stand by my previous statement, sir.
Director Coates?
I do likewise.
Well, let me ask this of everyone on this panel. Is anyone aware of any effort by anyone in the White House or elsewhere to seek advice on how to influence any investigation?
My answer is absolutely no, Senator.
No one has anything to add to that.
I don't understand the question.
The question is, are you aware of any efforts by anyone in the White House or the executive branch looking for advice from other members of the intelligence community about how to potentially influence an investigation?
Are you talking about me? No.
No.
Okay. Who wants to answer? I'm sorry.
I'm not sure I understand the question, but if you're asking whether I'm aware of requests to other people in the intelligence community, I am not.
Seeking advice on how we could potentially influence someone. You're not aware of anyone ever saying or reporting that to you?
No, sir.
Has anyone ever come forward and said, I just got a call from someone at the White House asking me what is the best way to influence someone on an investigation?
I've never received anything.
I have no direct knowledge of such a
There
call.
was an allegation made in one of the press reports, and that's why I asked. On a separate topic. I'm sorry. Who does? Mr. Rosenstein.
Our confusion, Senator, we just want to make sure we're clear on the question. The answer is no, as I understand it, but I'm not sure I'm familiar with the particular media report that you're referring to.
All right. I'm running out of time. I do want to ask this because this is important. Did the NSA routinely and extensively and repeatedly violate the rules that were put in place in 2011 to minimize the risk of collection of upstream information?
Have we had compliance incidents? Yes. Have we reported every one of those to the court? Yes. Have we reported those to our congressional oversight in Congress? Yes. Have we reported those to the Department of Justice and the Director of National Intelligence? Yes.
Did, under the Obama administration, was there a significant uptick in efforts and incidents of unmasking from 2012 to 2016?
I don't know that. I have to take that for the record.
Who would know that?
To be honest, we have the data, but I don't know that off the top of my head. I couldn't tell you unmasking on a year-by-year basis for the last 5 years. I apologize. I just don't know off the top of my head.
Thank you.
Senator Wyden.
Thank you very much, Mr. Chairman. I've noted the conversations you've had with my colleagues with respect to the content of conversations that you may have had with the President. My question is a little different. Did any of you four write memos, take notes, or otherwise record yours or anyone else's interactions with the President related to the Russia investigation?
I don't take any notes.
Let's just get the four of you on the record.
Senator, I rarely take notes. I've actually taken a few today. But I am not going to answer questions concerning the Russia investigation. I think it's important for you to understand.
Not on whether you wrote a memo.
I'm not going to answer any questions,
Okay.
Senator, about the
My
Russia
time's going to be short. Whether you wrote a memo, notes, anything.
I also am not going to comment on any conversations I may have had or notes taken or not taken relative to the Russia investigation.
Okay.
And likewise, I'd take the same position.
Director Coates, on March 23rd, you testified to the Armed Services Committee that you were not aware of the President or White House personnel contacting anyone in the intelligence community with a request to drop the investigation into General Flynn. Yesterday, the Washington Post reported that you had been asked by the President to intervene with Director Comey to back off of the FBI's focus on General Flynn. which one of those is accurate?
Senator, I will say once again, I'm not going to get into any discussion on that in an open hearing.
Both of them can't be accurate, Mr. Director. Mr. Director, as recently as April, you promised Americans that you would provide what you called a relevant metric for the number of law-abiding Americans who were swept up in the FISA 702 searches. This morning, you went back on that promise, and you said that even putting together a sampling, a statistical estimate, would jeopardize national security. I think that is a very, very damaging position to stake out. We're going to battle it out in the course of this because there are a lot of Americans who share our view that security and liberty are not mutually exclusive. We can have both. And you rejected that this morning. You went back on a pledge, and I think it is damaging to the public. Now let me...
Senator, could I answer the question?
Mr. Director, my time is short, and I want to ask you about one other 702.
Well, I would like to answer your question.
Briefly.
What I pledged to you in my confirmation hearing is that I would make every effort to try to find out why we were not able to come to a specific number of collection on U.S. persons. I told you I would consult with Admiral Rogers. I told you I would go to the National Security Agency to try to determine whether or not I was able to do that. I went out there. I talked to them. They went through the technical details. There were extensive efforts on the part of, I learned, on the parts of NSA to try to come to get you an appropriate answer. We were not able to do that.
Respectfully, that's not what you said. You said, and I quote, "We are working to produce a relevant metric." Now let me go to my other question.
But we were not able to do it, to achieve it. So working to do it is different than doing it.
You told the American people that even a statistical sample would be jeopardizing America's national security. That is inaccurate and I think detrimental to the cause of ensuring we have both security and liberty. Now here's my other question. We are trying to sort out
Can the witness respond?
Who are the targets?
Apparently not.
Who are the targets of a 702 investigation? Director Comey gave 3 different answers in a hearing a month ago. And I think it would be very helpful if you would tell us who, in fact, is a target of these investigations. I want to go after serious foreign threats, but we don't know as of now, with Director Comey having given 3 different answers, who the targets are. Mr. Director.
Well, I can't speak for former Director Clapper. Targets, as I understand, are non-U.S. persons, foreign individuals are the targets in terms 702 is directed and prohibited from directing targets on U.S. persons.
My time is up. I will tell you, Director Comey gave 3 answers. He finally said, I could be wrong, but I don't think so. I think it's confined to counterterrorism, to espionage, and finally he said he didn't think a diplomat could be targeted. So we need you all, in addition to protecting the liberties of the American people, to tell us who the targets are. Thank you, Mr. Chairman.
I would like to respond to that by saying some of those targets are classified, highly classified.
I understand that.
Some of those targets, by revealing those names of those targets, release the methods that we use, and then it's turned against us, and could cost the lives or put some of our agents in significant...
Director Comey listed a number of targets, which is why there's confusion. He said that on the record. We need you to tell us on the record as well, consistent with protecting sources and methods.
Senator Collins.
Thank you, Mr. Chairman. Director Coates, first let me thank you for a very cogent explanation of Section 702 and the fact that it cannot be used to target any person located in the United States, whether or not that person is an American. I think there's a lot of confusion about Section 702, and I appreciate your clear explanation this morning. I have a question for each of you that I would like to ask, and I want to start with Admiral Rogers. Admiral Rogers, did anyone at the White House direct you on how to respond today, or to were there discussions of executive privilege?
Have I asked the White House, is it their intent to invoke executive privilege? Yes. The answer I gave you today reflects my answer, no one else's.
What were you passing that?
Director Coates.
My answer is exactly the same.
I did never say that.
Deputy Attorney General Rosenstein.
I have not had any communications with the White House about invoking executive privilege today.
Director McCabe.
I have not had any conversations with the White House about executive privilege today either.
Admiral Rogers, in January, the FBI, the CIA, and NSA jointly issued an Intelligence Committee assessment on Russian involvement in the presidential elections. You've testified today that the IC relied in part on 702 authorities to support its conclusion that the Russians were involved in trying to influence the 2016 elections. Can you provide us with an update on NSA's further work in this area?
In terms of the Russian efforts, largely? Yes, ma'am. We continue to focus analytic and collection effort trying to generate insights as to what the Russians and others are doing, particularly with respect to efforts against U.S. infrastructure, U.S. processes like elections. We continue to generate insights on a regular basis. If my memory is right, I testified before the CISI. We did open threat assessment, and in that hearing, which I think was the 11th of May, I reiterated we continue to see this similar activity that we identified and highlighted in the January report. Those trends continue. Much of that activity continues.
It's my understanding that President Obama requested the report that was issued in January. Is that correct?
Yes, ma'am. He asked for a consolidated single input from the IC as to the question, did the Russians or did they not attempt to influence the U.S. election process?
So could you explain the difference between the requests from President Obama for that unclassified assessment and the allegations that President Trump requested that you publicly report on whether or not there was any intelligence concerning collusion between the Russians and the members of the Trump campaign, President Trump's campaign?
So I apologize. I guess I'm confused by the question. Again, I'm not going to comment on any interactions with the president. I just don't feel that is appropriate. As I previously testified, I stand by that report.
Let me ask a broader question that I truly am trying to get a handle on, and that is, how does the intelligence community reach a decision on whether or not to comply with a request that comes from the President of the United States? Obviously, you report to the President of the United States, and I'm interested in what process you go through to decide whether or not to undertake a task that's been assigned by the President, by any President.
So off the top of my head, I would say we comply unless we have reason to believe that we are being directed to do something that is illegal, immoral, or unethical. In which case, we will not execute that.
Senator Heinrich.
Director McCabe, did Director Comey ever share details of his conversations with the President with you? In particular, did Director Comey say that the President had asked for his loyalty?
Sir, I'm not going to comment on conversations the director may have had with the president. I know he's here to testify in front of you tomorrow. You'll have an opportunity to ask him those things then.
I'm asking you, did you have that conversation with Director Comey?
And I've responded that I'm not going to comment on those conversations.
Why not?
Because for two reasons. First, as I mentioned, I'm not in a position to talk about conversations that Director Comey may or may not have had with the President.
I'm not asking you that. I'm asking about conversations that you had with Director Comey.
And I think that those matters also begin to fall within the scope of issues being investigated by the special counsel, and it wouldn't be appropriate for me to comment on those today.
So you're not invoking executive privilege, and obviously it's not classified. This is the Oversight Committee. Why would it not be appropriate for you to share that conversation with us?
I think I'll let Director Comey speak for himself tomorrow in front of this committee.
We certainly look forward to that, but I think your unwillingness to share that conversation is an issue. Director Coates, you've said as well that it would be inappropriate to answer a simple question about whether the President asked for your assistance in blunting the Russia investigation. I don't care how you felt. I'm not asking whether you felt pressured. I'm simply asking, did that conversation occur?
And once again, Senator, I will say that I do believe it's inappropriate for me to discuss that in an open session.
You realize, and obviously this is not releasing any classified information, but you realize how simple it would simply be to say, no, that never happened. Why is it inappropriate, Director Coates?
I think conversations between the President and myself are, for the most part...
you seem to apply that standard selectively.
No, I'm not applying it selectively. I'm just saying I don't think it's appropriate.
You can clear an awful lot up by simply saying that never happened.
I do not share with the general public conversations that I have with the President or many of my colleagues within the administration that I believe should not be shared.
Well, I think your unwillingness to answer a very basic question speaks volumes.
It's not a matter of unwillingness,
Mr. Rosenstein. It is a matter of unwillingness.
It's a matter of how I share it and whom I share it to. And when there are ongoing investigations, I think it's inappropriate to.
So you don't think the American people deserve to know the answer to that question?
I think the investigations will determine that. And you're part of the investigation.
Mr. Rosenstein, did you know when you wrote the memo that was used as the primary justification for firing Director Comey that the administration would be using it as the primary justification?
Senator, as I know you're aware, I have there are a number of documents associated with me that are in the public record. The memorandum I wrote concerning Director Comey is in the public record. The order appointing the special counsel is in the public record. The press release I issued accompanying that order is in the public record, and a written version of the statement that I delivered to.
Were you aware that it would be the primary justification for his firing?
Pardon me, Senator. 100 United States senators and 435 congressmen is in the public record. I answered many questions in the closed briefings of the 100 senators.
But you're not answering this question.
And as I explained in those briefings, Senator, I support Mr. McCabe on this. We have a special counsel who is investigating, now responsible for the Russian
investigation. At this point, you filibuster better than most of my colleagues, so I'm going to move on to another question and say that given that the President stated that the FBI director, that his firing was in response to investigations into Russia, which he made very clear in Lester Holt's interviews, you've talked with both the President and the Attorney General about this firing. In light of Mr. Sessions' recusal, what role did the Attorney General play in that firing, and was it appropriate for him to write the letter that he wrote in this case?
I'm not trying to filibuster, Senator. I think I only took about 30 seconds, but I am not going to comment on that matter. I'm going to leave it to Special Counsel Mueller to determine whether that is within the scope of his investigation, and I believe that's appropriate for Mr. McCabe and me to do that.
Okay, so you can't comment on recusal and what's inside and outside the scope of that recusal.
Mr. Chairman, we ought to let the witness answer the question.
Second the motion. So, I'm sorry, your specific question is what's in the recusal, and my understanding is the recusal you're referring to is also in the public record, and I believe it speaks for itself.
Thank you, Mr. Chair.
Senator Blunt.
Director McCabe, on May the 11th, when you were before this committee, you said that there has been no effort to impede the Russian investigation. Is that still your position?
It is, but let me clarify, Senator. I think you're referring to the exchange that I had with Senator Rubio, and my understanding, at least my intention in providing that answer, was whether or not the firing of Director Comey had had a negative impact on our investigation. And my response was then and is now that the FBI investigated and continues to investigate, and now, of course, under the rubric of the special counsel, the Russia investigation in a appropriate and unimpeded way before Director Comey was fired and since he's been gone.
Well, I think as I recall that conversation, it was a discussion about whether there were plenty of resources, whether the funding was adequate, and what you were reported to have said, I haven't looked at the exact transcript, but I have looked at the news article, was that you were aware of no effort to impede the Russian investigation.
We did talk about resource issues and whether or not we had asked for additional resources to pursue the investigation. And I believe my response at the time was we had not asked for additional resources and that we had adequate resources to pursue the investigation. That was true then, is still true today.
And you would characterize your quote as no effort to impede the Russian investigation as still accurate?
That's correct.
On the 702 issue, when the FBI wants to follow up on or pursue a U.S. person in or outside the United States, what court do you go to get that to happen? Do you go to the FISA court as well?
If we are seeking collection under 702?
No, if you're, how do you relate to 702? Do you ever seek collection under 702?
Sure, yes we do. So so let me step back just a minute. So of course, when the FBI seeks electronic surveillance collection on a U.S. person, we go to the FISA court and get a Title I FISA order to do so. If we have an open, full investigation on a foreign person in a foreign place, and the collection is for the purpose of collecting foreign intelligence, we can nominate that person, or that, as we refer to it internally, the selector, whether it's an email address or that sort of thing. We can nominate that for 702 coverage. We convey that nomination to the NSA, and they pursue the coverage under their authority.
But you would be the person that would pursue coverage for a U.S. person either here or outside the United States.
That's correct, Senator. We are
the FBI.
We are the U.S. person agency. That's right.
And Admiral Rogers, Senator Feinstein mentioned that last year 1,139 U.S. persons were, the phrase we're using now, unmasked for some purpose. Is that a number you agree with?
It's in the 2016 ODNI generated transparency report. From memory, the number is actually 1,934 from memory. It could be
sorry.
wrong, but
so I misheard. But 1,900. What would the number have been in 2015?
to be honest, I don't know. I'd have to take that one for the record. I do know that we didn't start with the transparency commitment that we made partnering with the DNI. We didn't start that until the latter end of 2015. So the 2015 data that's been published as a matter of public record is a subset of the entire calendar year. 2016 is the first calendar year where we have published all the data for the entire
Director
year.
Coates, do you have any information on that?
Well, I've seen the number. I don't recall what it was, and I just asked my staff.
Right, I guess what I'm asking, and you can take this for the record, is was there an increase in 2016? Did you have significantly more requests based on your subset in 15 happen in 16 than you had had?
I don't know off the top of my head. We'll take it for the record, but I will say this. 702 collection has continued. The amount of total collection has increased generally every year. It's more and more impactful for us. It generates more and more value.
And when 702 generates information that would indicate there was a U.S. person involved in criminal activity, what do you do with that information?
If we report it to either to DOJ and the FBI, because we're not a criminal organization.
And what do you do if you get that information at DOJ, Mr. Rosenstein? Information from a 702 collection that
we become aware.
clearly indicates there's a crime involving a U.S. person.
I hesitate only because that's actually an FBI issue, so I would refer to Mr. McCabe.
Mr. McCabe.
Sure. So we take that referral, and if that's a U.S. person, we begin to build an investigation aiming towards Title I FISA collection.
With adequate protections for U.S. persons and that entire chain of transmission of material.
That's right.
Thank you, Chairman.
Senator King.
Thank you, Mr. Chairman. First on 702, like Senator Feinstein, I want to express my support for this important tool for our intelligence agencies. I do have a concern which we can discuss perhaps in closed session about the process by which American names which are incidentally collected are then queried. I'm concerned by the distinction between query and search and where we run into the Fourth Amendment. It strikes me as bootstrapping to say we collected it legally under 702 and then we can go and look at these American persons, and I believe that the Fourth Amendment imposes a warrant requirement in between that step, which is not present in the present process. We can discuss that at greater length. Mr. McCabe, I'm puzzled by your refusal to answer Senator Heinrich's question about a conversation you may have had with Director Comey. What's the basis of your refusal to answer that question?
Sure. As I stated, I think first, I can't sit here and tell you whether or not that those conversations that you're referring to.
Why not? Do you not remember them?
No, I'm sorry, sir. I don't know whether conversations along the lines that you have described fall within the purview of what the special counsel is now investigating.
Is there some prohibition in the law that I'm not familiar with that you can't discuss an item and that you've been asked directly a question?
It would not be appropriate for me, sir, to discuss issues that are potentially within the purview of the special counsel's investigation.
And that's the basis of your refusal to answer this question?
Yes, sir. And that and knowing, of course, that Director Comey will be sitting behind this table
it's your
tomorrow.
position that the special counsel is entitled to ask you questions about this, but not an oversight committee of the United States Congress?
It is my position that I have to be particularly careful about not stepping into the special counsel's lane, as they have now been authorized by the Department of Justice.
I don't understand why the special counsel's lane takes precedence over the lane of the United States Congress and an investigative and oversight committee. Can you explain that distinction? Why does the special counsel get deference and not this committee?
Sir, I'd be happy to...
Is there some legal basis for that distinction?
I would be happy to take that matter back to discuss it more fully with my general counsel and with the department, but right now that's the...
On the record, I would like a legal justification for your refusal to answer the question today, because I think it's a straightforward question. Mm-hmm. It's not involving discussions with the President. It's involving discussions with Mr. Comey. The gentleman, Mr. Director Coates and Admiral Rogers, I think you testified, Admiral Rogers, that you did discuss today's testimony with someone in the White House?
I said I asked, did the White House intend to evoke executive privileges associated with any interactions between myself and the President of the United States?
And what was the answer to that question?
To be honest, I didn't get a definitive answer, and both myself and the DNI are still talking to the White House.
So then I'll ask both of you the same question. Why are you not answering these questions? Is there an invocation by the President of the United States of executive privilege? Is there or not?
Not that I'm aware of.
Then why are you not answering our questions?
Because I feel it is inappropriate, Senator.
What you feel isn't relevant, Admiral. What you feel isn't the answer. The answer is, why are you not answering the questions? Is it an invocation of executive privilege? If there is, then let's know about it. If there isn't, answer the questions.
I stand by the comments I've made. I'm not interested in repeating myself, sir. And I don't mean that in a contentious way.
Well, I do mean it in a contentious way. I don't understand why you're not answering our questions. You can't. When you were confirmed before the Armed Services Committee, you took an oath. Do you solemnly swear to give the committee the truth, the full truth, and nothing but the truth? So help you God. You answered yes to that.
And I've also answered that those conversations were classified, and it is not appropriate in an open forum to discuss those classified conversations.
What is classified about a conversation involving whether or not you should intervene in the FBI investigation?
Sir, I stand by my previous comments.
Mr. Coates, same series of questions. What's the basis for your refusal to answer these questions today?
The basis is what I've previously explained. I do not believe it is appropriate for me to
What's the
get into
basis?
it.
I'm not satisfied with I do not believe it is appropriate or I do not feel I should answer. I want to understand a legal basis. You swore that oath to tell us the truth, the whole truth, and nothing but the truth, and today you are refusing to do so. What is the legal basis for your refusal to testify to this committee?
I'm not sure I have a legal basis, but I'm more than willing to sit before this committee and during its investigative process in a closed session and answer your question.
Well, we're going to be having a closed session in a few hours. Do you commit to me that you're going to answer these questions in a direct and unencumbered way?
Well, that closed session you're going to have in a few hours involves the staff going over the technicalities of a number of these issues and doesn't involve us. But
is it your testimony that when you are before this committee in a closed session, you will answer these questions directly and unequivocally and without hesitation?
I plan to do that, but I do have to work through the legal counsel at the White House relative to whether or not they're going to exercise executive.
Admiral Rogers, will you answer these questions in a closed session?
I likewise respond as the DNI has. I certainly hope that that is what happens. I believe that's the appropriate thing. But I do have to acknowledge, because of the sensitive nature and the executive privilege aspects of this, I need to be talking to the General Counsel in the White House. I hope we come to a position where we can have this dialogue. I welcome that dialogue, sir.
I hope so, too. And I would just add in conclusion that both of you testified you had never been pressured under 3 years. I would argue that you have waived executive privilege by, in effect, testifying as to something that didn't happen. And I believe you opened the door to these questions. And it is my belief that you are inappropriately refusing to answer these questions today. Thank you, Mr. Chairman.
Before I turn to Senator Lankford, let me say that the Vice Chairman and I have had conversations with Acting Attorney General Rosenstein when a special counsel was named. And as I had shared with the members of this committee prior to that as we carried out an investigation, there would come a point in time either with an investigation that was currently ongoing at the FBI, or if there was a special counsel with the special counsel, where there would be avenues that this committee could not explore. And it was my hope that already the Vice Chair and I would have had that conversation with the special counsel. We have not. We've made the request. We intend to have it. And I think that both of us anticipated that we would reach this point at some point in the investigation. We are there where there are some things that will fall into the special counsel and or an active investigation, Vice Chairman.
Let me just say, though, that at this point, we've not had that conversation with Mr. Mueller. We've not been waived off on any subject. And the way I'm hearing all of you gentlemen is that Mr. Mueller has not waived you off from answering any of these questions. Is that correct?
I've had no conversations with Mr. Mueller. I've been out of the country for the last 9 days, and I haven't had an opportunity
have any of you
to talk to him.
had, because if you've not had questions waived off with Mr. Mueller, I think, frankly, and I understand your commitment to the administration, but that Senator King, Senator Heinrich, and my questions deserve answers, and at some point the American public deserves full answers.
I'm going to ask Mr. Rosenstein to address that.
Thank you, Mr. Chairman. And I'm sensitive to your desire to keep our answers brief, and my full answer actually would be very lengthy. But my brief answer, from my perspective with the Department of Justice, and I've been there for 27 years, and Mr. McCabe also is a career employee of the Department of Justice, our default position is that when there's a Justice Department investigation, we do not discuss it publicly. That's our default rule, so nobody needs to.
Is that the rule for the President of the United States as well?
I don't know what.
Because that is what the questions are being asked about. Reports that nobody has laid the rest here, that the President of the United States has intervened directly in an ongoing FBI investigation, and we've gotten no answer from any of you. And frankly, we've at least heard from Director Coates and Admiral Rogers that they've not been asked to recuse an answer because of Director Mueller. And I don't understand why we can't get that answer.
So I'm not answering for Director Rogers or Director Coates. I'm answering for Director McCabe and myself with regard to the Department of Justice.
Senator Lankford.
Director McCabe, can I ask you, do you feel confident at this point the FBI is fully cooperating with special counsel for any request in communication and setting up of the coordination between the offices for documents, work products, insight, anything the special counsel, as they're trying to get organized and get prepared for the investigations they're taking on. Is everyone in the FBI fully cooperating with special counsel?
Absolutely, sir. I'm absolutely confident of that. We have a robust relationship with the special counsel's office, and we are supporting them with personnel and resources in any way they request.
Thank you. Admiral Rogers, this spring, NSA decided to stop doing about queries. That was a long conversation that's happened there. It's now come out in the public about that conversation, that was identified as a problem. The court agreed with that, and that has been stopped. What I need to ask you is, who first identified that as a problem?
The National Security Agency did.
Okay, so how did you report that? Reported that to who? How did that conversation go once you identified we're uncomfortable with this type?
So in 2016, I had directed our Office of Compliance, let's do a fundamental baseline review of compliance associated with 702.
Okay.
We completed that effort. My memory is I was briefed on something like October the 20th. That led me to believe the technical solution that we put in place is not working with the reliability that's necessary here. I then, from memory, went to the Department of Justice and then on to the FISA court at the end of October. I think it was something like the 26th of October, and we informed the court we have a compliance issue here, and we're concerned that there's an underlying issue with the technical solution we've put in place. We told the court we were going to need some period of time to work our way through that. The court granted us that time. In return, the court also said, we will allow you to continue 702 under the 16 authorizations, but we will not reauthorize 17 until you show us that you have addressed this. We then went through an internal process, interacted with the Department of Justice as well as the court, and by March we had come to a solution that the FISA court was comfortable with. The court then authorized us to execute that solution and also then granted us authority for the 702 effort.
So you reported initially to the court this is an issue, or the court initially came to you and said we have an issue?
I went to the court and said we have an issue.
And the court said we agree we have a problem as well?
Jack.
And then it got held up, went through the process of review, and the court is now signed off on the other 16.
That is correct.
So how does this harm your collection capabilities to be able to not do the about collections?
So I acknowledge that in doing this, we were going to lose some intelligence value, but my concern was I just felt it was important. We needed to be able to show that we're fully compliant with the law. And the technical solution we had put in place, I just didn't think was generating the level of reliability. And as a result of that, I said, we need to make the change. I will say this, and the FISA's court opinion also says the same thing. I also told the court at the time, if we can work that technical solution in a way it generates greater reliability, I would potentially come back to the Department of Justice and the court to recommend that we reinstitute it. And in fact, the court acknowledged that in their certification.
When you say greater reliability, tell me what you mean by that.
Because it was generating errors. Our Office of Compliance highlighted the specific number of cases in 2016, and I thought to myself, clearly it's not working as we think it is. We were doing queries unknowingly to the operator in a handful of situations against U.S. persons, and I just said, hey, that is not in accordance with the intent of the law.
Yeah, clearly it's not only the intent, it's the actual statute
Correct,
itself.
right, the statute,
that we protect U.S. persons from
yes,
this is foreign directed. So what I'm hearing from you is the accountability system worked.
Yes, sir.
That the issue rose up. We're collecting. We do have information on U.S. persons. We don't want to get that information. Immediately the process started going through to be able to stop it. The court then put the final stop on it. It was corrected, and then that's now cleared.
Yes, sir. And in fact, we're purging the data as well. Not only have we stopped doing it, but we're purging the data that we had collected under the previous authorization.
So the issue on 702, most Oklahomans that I interact with don't know the term 702. But if I ask them, should we collect information on terrorist organizations and terrorists overseas who are planning to carry out attacks on us and our allies, they don't hesitate. They say, absolutely, we should do that. Now, they don't want collection on themselves and their mom, but they absolutely want us to be able to target terrorists. And so the issue I think when we talk about 702 on this dais is a normal conversation back home that if we miss something internationally, everyone says, I thought we were doing this. Why aren't we? So I fully appreciate the civil liberties conversation, the privacy questions. Those are things I'm also passionate about. And it's very interesting for me to be able to hear from you that you're passionate about and NSA is passionate about to make sure that we're not collecting on Americans. So I appreciate that. And in this case, when it comes out in the public media that this has occurred, it actually shows the system itself worked. When there was a query going on that was collecting on Americans, it was stopped immediately, data's purged. But we're still continuing to be able to target on threats internationally. And I do appreciate that. Thank you. I appreciate you back the time.
Senator Manchin.
Thank you, Mr. Chairman. I want to thank all four of you for your service. And you all are held at the highest, I think the highest regards by your colleagues and your peers. And I think that speaks volumes of the character of all four of you. And I appreciate that very much. We have a committee here, which I'm so proud to be service. I'm brand new on the committee. This is my first time at this. And I don't think there's a person up here that doesn't want to find out the facts and the truth and be able to go back home and explain to the Democrat and Republican colleagues, and no matter what political persuasion, that we have gotten the facts. We got it from our intel, which we truly appreciate and respect the quality of job and work that you do. And this is our findings. We're having a hard time getting there, as you can tell, and I respect where you all are coming from. I hope you could understand that sooner or later we're going to have to. There has to be one element of this government that the public can look at and said, this is not politically motivated. This is not a witch hunt. No one's trying to harm anybody. We just want to do the business of our government and our country and do the best that we can for that and make sure that they have the confidence in the people that they've put at the head and have elected. That's what we're trying to get to. Today's been very difficult. By me sitting here listening to some of the answers and an ability to answer some of the questions. If the Intelligence Committee in the Senate cannot get answers we know in an open setting like this, are these answers that we're asking, the questions that were simply asked today, would they be given into a classified intel setting that we would have? Could you answer differently than what you've given us an open session? I think, Director Coach, you said that you would be able to answer differently in a...
I think I've made that very clear.
Yes.
I've tried
Admiral
to.
Rogers, would you be able to?
And likewise, I certainly hope so.
Mr. Rosenstein, would you?
Senator, speaking for Mr. McCabe and myself, we have been involved in managing the criminal investigation. And so I would ask that you, as Chairman Bear suggested, it's really appropriate for Director Mueller, since we've turned over control of that investigation to him, to make the determination in the first instance about what we can and can't speak about. So I would encourage you to use Mr. Mueller as your point person as to whether or not it's appropriate to reveal that information.
Well, let's just say that the questions that was asked to Mr. McCabe, I think they weren't anything on the investigation side. It was asked pretty personal, directly. Could you answer differently in a classified setting, sir?
I would reiterate the DAG's comments that it's at this point, with the special counsel involved, it would be appropriate for the committee to have an understanding with the special counsel's office as to where those questions would go. But I would also point out that as we have historically, when we are investigating sensitive matters in which operational security is of utmost importance, members of the intelligence community typically come and brief the leadership, congressional leadership, on sensitive investigative matters. We have done so. I have done so. Director Comey has done so prior to the appointment of the special counsel. And some of the questions that you have asked this morning were addressed in those closed, very restricted, very...
Let me say this, that if it would be the desire of the chairman and vice chairman, if we could, since we have a classified hearing scheduled for 2 o'clock this afternoon, would you all make yourself available? Since it doesn't linger on. There's been a lot of questions, a lot of anticipation, a lot of build-up anxiety, if you will. I think you could really help an awful lot of us clear the day up, if you will.
If I could address the Senator's question, this afternoon is set with technical people to walk us through 702. Rest assured that we will take the first available opportunity to have people back in closed session to address those questions that they can address. And hopefully prior to that, the Vice Chair and I would have an opportunity to meet with Director Mueller to determine whether that fits within the scope of his current investigation, and we will do that.
Well, Mr. Chairman, the only thing I'm saying is that I know that you can tell by the intensity of the questions here that there's a lot of concerns right now, and we have both Director Coates and Admiral Rogers are willing to say in a classified hearing that they would be able to answer differently. That's the only reason I was bringing that up, and we had it this afternoon. I would hope that would maybe be considered. Let me ask a question. Does the President support Section 702 reauthorization of the FISA and expanded authority?
Absolutely.
Everyone?
Full support.
Full support there. Did the President ask, or was he given any specific intelligence or info concerning the Russian active measures in the 2016 presidential election? Was he briefed on that? Did he ask for that briefing, or did it automatic briefing that you give? Admiral Rogers?
Well, all that took place before I was
So I will say, yes, he was briefed on the results of the intelligence community assessment. I was part of that in January prior to his assuming his duties. He and I have discussed as well the specifics of that assessment subsequent to him after he had become the president, assumed the duties.
Let me just say, just in finishing up, I just would hope that you all, with your expertise and all of your knowledge, would help us put closure to this sooner or later. I mean, we need your help. We need your assistance. We really do. And this is a committee that I think will take the facts as you give them to us and decipher that and come up with some appropriate action and a final report, which is, I think, what the public is looking for. We can't do that without your assistance. So thank you all.
And Senator, I fully understand that statement. And as the chairman mentioned, the procedures he's going to put in place relative to when we hold that hearing and the relationship it is to the official investigation that's going on by Director Mueller will dictate when and how we do that.
I think we need you in the skiff sooner than later. Thank you.
Senator Cotton.
Thank you, gentlemen. I want to talk about the import of Section 702 to our national security. Admiral Rogers, I'll direct most of these questions to you as the subject matter expert on the panel on signals intelligence from foreign threats, though I might turn to some of our lawyers for legal questions. Does Section 702, Admiral Rogers, allow you to collect information on U.S. citizens?
As intentionally targeted individuals?
Yes,
no.
Intentionally target them?
No.
Does it allow you to target foreigners to do what's called reverse targeting of U.S. citizens, knowing those U.S. citizens are in communications?
No, it does not.
Does it allow you to collect information on foreigners who are on U.S. soil?
No.
It doesn't?
702 is outside the United States.
So you can collect information on an ISIS terrorist in Syria, and he comes to the United States, and you can no longer collect information on his cell phone or his email address.
We're a foreign intelligence organization. We coordinate with the FBI, but yes, sir, we don't do internal domestic collection broadly.
Mr. Rosenstein, do foreigners have constitutional rights?
When they're in the United States, Senator, different rules apply, and that's why I think it's important for people to understand that Section 702 applies only in circumstances where it's a foreign national outside the United States. If they're inside the United States, we would need to rely on other provisions of FISA to do that collection. So, yes, we can do it, but we need to apply different rules. And Mr. McCabe, as the director indicated, is responsible for that.
Mr. McCabe, what happens when an ISIS terrorist comes from Syria to the United States and Director Rogers or Admiral Rogers can no longer use Section 702 to monitor his electronic communications?
Yeah, Admiral Rogers folks notify mine, and then we work together to pursue coverage under different elements of the FISA statute.
I'm sure you work as hard as you can to make sure that it's absolutely seamless, but it does seem to me that Section 702, because it's limited to foreigners on foreign soil without targeting any U.S. persons anywhere, goes the extra mile to protect the constitutional rights of American citizens and even the supposed constitutional rights of foreigners when they come on U.S. soil. That's one reason why I support the permanent extension of Section 702, and I introduced legislation to that effect yesterday with the support of all 7 Republicans on this committee. Tom Bossert, the counterterrorism and homeland security advisor to the president, write in today's New York Times about our legislation. The Trump administration supports this bill without condition. Admiral Rogers, is that your position?
Could you repeat it again? I apologize, sir.
The Trump administration supports this bill without condition.
Yes.
On a scale of 1 to 10, how enthusiastic would you be if this bill passed? You can go over 10 if you would be excessively enthusiastic.
I would be ecstatic that we'd be in a position to continue to generate significant insights for this nation's security.
So you'd dial it straight up to 11?
Yes, sir.
Okay. Director Coates?
My level's about 100.
Mr. Rosenstein?
Senator, I'm not familiar with the rating system. I do think it's very important.
Director McCabe.
I'm at 11.